What is a law? We can better understand the law when we understand our communities. Laws teach us how to behave properly and inform us of the rules we all must follow. So first, we need to know what a law is, who makes the laws, and how laws are made. Let's get started. Imagine that you and your family are sitting down to play a game. First, you would need to know the rules. Someone in your family would read the rules of the game aloud. Then, you would clearly understand how to play. The rules, just like laws, tell us how to play fairly and how to make sure that everyone is treated in the same way. Every country has its own set of laws, and each is unique to that country. For example, in the United States, the law is that drivers must drive on the right side of the road. In England, on the other hand, the law is that drivers must drive on the left side of the road. If you and your family are traveling to England, you can see how knowing the law can keep you safe. It's the system of rules which a particular country or community recognizes as regulating the actions of its members and which it may enforce by the imposition of penalties. What is law, in its legal sense? Blackstone said that law, in its most general and comprehensive sense, is that rule of action which is prescribed by some superior and which the inferior is bound to obey. Civil law he defined as a rule of civil conduct prescribed by the supreme power in a state, commanding what is right and prohibiting what is wrong. In Blackstone's definitions there are two main concepts. 1. The concept of a superior and 2. The concept of a command. Is law something set or given by a superior to an inferior, or by a sovereign to a person in a state of subjection? This concept of Blackstone would exclude all international law, as perhaps it should, but it has been criticized on this account. It would also exclude constitutional law and all law adopted by a people of a country, as in the United States. Such constitutions, and for that matter all law in such jurisdictions, is adopted by the sovereign people for their own control, not by some superiors for other inferiors. Since Blackstone's definition does not include this sort of law, the proper conclusion is not that there is no such law, but that the definition is inadequate. In the United States, as concerns all civil as distinguished from criminal law, law is not a command. The law does not command people not to commit trespasses and other torts, nor promises to perform their promises, except perhaps in the few rare cases where the remedies of injunction and specific performance are available. The state has policemen, judges, and other officers of the law, but they are not ordinarily commanding anyone to do anything with respect to what is known as civil law. They may give people advice. In the course of time they may bring people into court for some civil wrong that they may have done. But they do not issue commands to people telling them how they must treat each other. As concerns criminal law, Blackstone's concept seems nearer the truth. It might easily be possible to think of the state as commanding the people not to commit certain criminal acts. Yet the true concept of criminal law is not that of something commanded not to be done. In this respect it is like civil law, as will be pointed out later on. Hence Blackstone's definition is inadequate in both respects. Leon Duguid was right when he said, "Law is not the command of a sovereign state, but a bylaw governing a group." What, then, is a correct definition of law? From what has been said above, it should be noted that law is a scheme of social control. It is not the simple thing that a command from a superior to an inferior would be. It is a complicated contrivance, a connected combination of things. It is a scheme. In the first place, the scheme is a form of social control. It is not a scheme of individual control. The individual is free to control his own conduct, so long as it does not affect others. He may choose his own vocation, choose his own domicile, and regulate his own conduct in 1,001 other ways without any interference by the law, provided he alone is concerned. But if his conduct affects the lives of his fellowmen, then there is a possibility of control by the law. In the second place, it should be noted that, while law is a scheme of social control, it does not attempt to control all social relations. It controls them only so far as social interests require such control. As human beings come in closer contact with each other, they have more wants or social interests. What is true of external things is true of personality. A solitary human being would have no wants against other human beings. Hence there would be no social interests. But the more people are thrown into contact with each other, the more social interests they have. People in rural districts do not have as many social interests as people in urban communities. People in small urban communities do not have as many social interests as people in large cities. As social life becomes more complex, more social interests have to be recognized. In the early history of the world, there were not as many social interests as there are today. In the early history of our country, there were not as many social interests as there are now. At first, the only social interest recognized was that of the preservation of the peace. Later, there was a social interest in the maintenance of the status quo. Society is made up of many conflicting and overlapping groups, as capitalists, laborers, farmers, consumers, producers, and the like. Representatives may be governed by self-interest and judges influenced by bias and prejudice. Under such circumstances, it is often difficult to decide what the social interest is. Yet, in the complex modern world, if many social interests were not recognized and protected, life would be intolerable. The human race, through warfare, degeneracy, ignorance, and laziness, would soon destroy itself. Law, then, is a scheme of social control. For the protection of Virginia law review those social interests which society in some way decides shall be protected. However, in order to understand the nature of law, it is necessary not only to know what its purpose is, but also how it accomplishes its purpose. As a matter of fact, the greater part of the scheme of social control known as law consists of the means whereby it accomplishes its purpose. We have already noted that the law does not protect social interests by sending someone out, like a policeman, to see that all people respect them. The scheme is much more complicated. What is the nature of this scheme? In order to find the answer to this question, let us examine the phenomena of the law. Let us keep our feet on the ground. Let us get the exact data, so that, after we have got the data, we may make our definition conform to the facts, instead of first framing a definition and then trying to make the facts conform to our definition. In pursuance of this policy, let us examine the law of contracts, which is one of the phenomena of the law. What do we have in a contract? A first thing which we observe is that we have a promise, or two promises each given for the other. But there is not anything magical in a promise. People are making promises all of the time. Most of them are not contracts and do not have any legal consequences. A contract is a promise which has legal consequences. What are they? Clearly, the law commands no one to make a contract. But after he has made a contract, the law has something to say about it. What is it? In the first place, it says that one person, the promisee, and both persons, if each is a promisee, has a legal right to the performance of the promise, and the other party is under a correlative legal obligation to perform the promise. Why? Because the promise in the form of a contract is one of such importance that its non-performance is liable to have bad social consequences, in that it would tend to destroy the general security which is necessary for a stable and permanent social order, or perhaps even to disturb the peace of society. In other words, because there is a social interest in general security which the law believes should be protected. In the second place, we observe that if a promiser who has made a contract breaks his promise, the law begins to do the only thing which looks the least like a command. It offers the facilities of the courts and legal procedure to the man wronged to enable him to get something as a substitute for what he ought to have received, and what he would have received if the other party to the contract had carried out his promise.